Welcome back to the Constitutional Clarion. I wasn't really intending to do a Clarion today, but having spent the entire day doing media interviews about what seems to be the most absurd topic of whether or not Senator Lidia Thorpe made an oath to the Queen's heirs and what the consequences are, it occurred to me that, well, at least someone is interested in this, maybe only the media, but in any event, maybe I should put it out as a Clarion for anyone else who might be interested. Now, for those of you who are overseas or somehow haven't heard of this particular hoo-ha in Australia, the story is as follows. Senator Lidia Thorpe was initially chosen to fulfil a casual vacancy in the Senate and then later elected to a 6-year term as a Green senator. Shortly afterwards, she left the Greens and is serving out the rest of her term as an independent senator. Initially, before coming to Canberra as a senator, she said that she would never swear an oath of allegiance to the monarch. When it was pointed out to her, however, that Section 42 of the Constitution means that she could not take up her seat in the Senate without doing so, her never turned into rather begrudging acceptance. Section 42 of the Constitution says that every senator, quote, shall, before taking his seat, make and subscribe before the Governor-General or some person authorised by him an oath or affirmation of allegiance in the form set forth in the schedule to the Constitution, unquote. The schedule requires that the senator swear or affirm that they will be faithful and bear true allegiance to the monarch and his or her heirs and successors according to law. So what does it mean to make and subscribe an oath or an affirmation? All right, an oath is sworn under God, an affirmation is made without the religious aspects to it. And an oath or an affirmation is made orally and then it's subscribed in writing by the member or senator signing what is known as the test roll. Now, this goes back many centuries in the United Kingdom when battles over allegiance did have a strongly religious aspect to them, and people would be required to swear oaths to test their allegiance to the monarch, hence the test roll. Failure to take an oath of allegiance in some cases could be treated as treason, resulting in the person being executed, as indeed happened in 1535 to Sir Thomas More and a number of others during the reign of Henry VIII. The test roll is the formal parliamentary document, previously a roll of parchment, which sets out the oath and which parliamentarians must sign before they can sit and vote in Parliament. Australia adopted that same practice of having a test roll from the United Kingdom for the purpose of subscribing to the oath. After the May 2022 general election and the changeover of the Senate on the 1st of July that year, the elected senators were sworn in. Senator Thorpe was absent and was later sworn in by the President of the Senate, under the authority of the Governor-General, on the 1st of August 2022. Senator Thorpe chose to do an affirmation rather than an oath. Her initial attempt at an affirmation involved her describing herself as Sovereign Lidia Thorpe and referring to the colonising Her Majesty Queen Elizabeth II. At that point, she was stopped by the President of the Senate, who stated that she was required to recite the affirmation as printed on the card before her, which set out the terms of the affirmation from the Constitution. Thorpe then made the affirmation using the required words, but doing so in an exaggerated manner. When she referred to the Queen's heirs, she aspirated the H so it sounded like heirs. Senator Thorpe then signed the test roll as well as the senator's roll, and then the President signed the test roll witnessing Senator Thorpe's signature. Senator Thorpe was, by that process, accepted by the House to sit and vote in the Senate. More recently, during the visit of King Charles to the Great Hall of the Commonwealth Parliament, Senator Thorpe interrupted proceedings by yelling at the King, quote, "You are not our King. You are not sovereign. "You committed genocide against our people. Give us back our land. Give us back what you stole from us," unquote. Now, after several more accusations, she finished by saying, "This is not your land. You are not my king. You are not our king," unquote. When later asked by the media about whether she had repudiated her affirmation, Senator Thorpe initially said that she had made her affirmation to the Queen's heirs, not her heirs, and that now as the Queen is no longer there, she doesn't know where her oath stands. The next day, Senator Thorpe recanted from this statement, saying that she had mispronounced the word, as her English grammar is not as good as others. Either way, it led to a storm in the media's teacup. So, what is the position? Can Senator Thorpe be disqualified and removed from Parliament for repudiating her affirmation of allegiance? Here it's important to point out that there is a big difference between how this is treated in Australia and in the United Kingdom. In the United Kingdom, the Parliamentary Oaths Act 1866 says that if any member of the House of Commons votes or sits without having made and subscribed the oath, he shall be subject to a like penalty for every such offence, and in addition to such penalty, his seat shall be vacated in the same manner as if he were dead. The penalty is £500 for each day the member sat without having taken the oath. The framers of the Commonwealth Constitution, which was drafted in the 1890s, would have known that this was how it was treated in the United Kingdom, but they chose to treat it differently. They did not include failure to take the oath in the grounds for disqualification of members of Parliament under sections 44 and 45 of the Constitution. As a consequence, it also does not trigger any penalty for sitting while disqualified under section 46 of the Constitution. The framers left this as a matter for the Houses to deal with as part of their internal parliamentary proceedings, with which the courts usually do not interfere. That's another important difference because in the United Kingdom there have been court cases about the validity of oaths because there are legal consequences, including penalties and the loss of the seat, that arise from failing to take a valid oath. In Australia, however, it's likely that the courts would treat the matter as non-justiciable, which means that the courts would not interfere and they would leave it as a matter for the Houses to resolve, just as they do in relation to money bills where there are no legal consequences. Could Senator Thorpe, however, be expelled? Well, the Parliamentary Privileges Act 1987 removed the power to expel, although theoretically, of course, this legislation could be changed. The Senate has powers to impose penalties, such as fines or even imprisonment, for an offence against the House, but this is limited under the Parliamentary Privileges Act to offences that amount to an improper interference with the free exercise by the House or a committee of its authority or functions, or the free performance of a member's duties. The Senate can also suspend members in relation to disorderly conduct. But actions outside the chamber, such as declaring that the king is not sovereign or not my king, would not seem to be disrupting the functions of the Senate. Could the Senate resolve that Senator Thorpe had not validly taken the oath to begin with because she was insincere, as shown by her other conduct, and could it then exclude her from sitting or voting in the House? As far as I'm aware, there's no authority about this in Australia. There are some older cases, however, in the United Kingdom, particularly from the times where the oath contained religious components. For example, in 1850 and 1851, two elected Jewish members of the House of Commons left out the words, quote, "upon the true faith of a Christian," unquote, from one of the required oaths, for the obvious reason that they were not Christians. The House of Commons passed a resolution that they were not entitled to vote or sit in the House until they took the oath in the correct form. This was upheld in the courts. The law was then later changed to exclude those offending words from the oath. Atheists also had problems with respect to the oath. Charles Bradlaugh was elected to the House of Commons a number of times in the 1880s, but even though he was prepared to swear the oath, despite being an atheist, the House of Commons would not regard the oath as valid. The matter went to court, and the Court of Appeal accepted that even if he took the oath in its existing form, his lack of belief in a supreme being meant that his oath had no binding effect, making him liable for penalties for sitting and voting as a member. Bradlaugh's campaigning eventually led to the Westminster Parliament accepting that an affirmation could be made by non-believers rather than requiring an oath. So there is at least some British precedent for a House passing a resolution to exclude a person from sitting based upon their sincerity in taking an oath, although all of these examples did occur at the time of first sitting rather than years later, as is the case here. It is, however, a potentially dangerous path to take, as others too may have reservations about the terms of the oath that they make. Queen Elizabeth I, at a time when failure to take an oath could lead to the block, said that she had no desire to make windows into men's souls. Wise words indeed. Thank you for watching the Constitutional Clarion, and I look forward to seeing you again next time. Goodbye.